Statute 600-5.0113. 1. Each limited liability company and each foreign limited liability company that has a certificate of authority under Section 605.0902 shall designate and continuously maintain in this state a registered office, which may be the same as its place of business in this state, and b. a registered agent, who must be 1. an individual who resides in this state and whose business address is identical to the address of the registered office, 2. another domestic entity that is an authorized entity and whose business address is identical to the address of the registered office, or 3. a foreign entity authorized to transact business in this state that is an authorized entity and whose business address is identical to the address of the registered office. 2. Each initial registered agent and each successor registered agent that is appointed shall file a statement in writing with the Department in the form and manner prescribed by the Department, accepting the appointment as registered agent while simultaneously being designated as the registered agent. The statement of acceptance must provide that the registered agent is familiar with and accepts the obligations of that position. 3. The duties of a registered agent are as follows. A. To forward to the limited liability company or registered foreign limited liability company at the address most recently supplied to the agent by the company or foreign limited liability company a process, notice, or demand pertaining to the company or foreign limited liability company which is served on or received by the agent. B. If the registered agent resigns, to provide the notice required under Section 605.0115, 2, to the company or foreign limited liability company at the address most recently supplied to the agent by the company or foreign limited liability company. 4. The Department shall maintain an accurate record of the registered agent and registered office for service of process, and shall promptly furnish information disclosed thereby upon request and payment of the required fee. 5. A limited liability company and each foreign limited liability company that has a certificate of authority under Section 605.0902 may not prosecute or maintain an action in a court in this state until the limited liability company complies with this section, pays to the Department any amounts required under this chapter, and, to the extent ordered by a court of competent jurisdiction, pays to the Department a penalty of $5 for each day it has failed to comply, or $500, whichever is less, and pays any other amounts required under this chapter. 6. For the purposes of this section, authorized entity means a corporation for profit, b. a limited liability company, c. a limited liability partnership, d. a limited partnership, including a limited liability limited partnership. We offer real estate, estate planning, probate, and business law. Call 321-206-3603 or visit easlerlaw.com to book a consultation. Offices in Melbourne, Florida. Virtual consultations worldwide.